Similar to virtually every other industry, municipal issuers are encountering historic uncertainty due to the COVID-19 pandemic. This uncertainty is affecting borrowing plans nationwide. Today, I'm going to start by discussing one of the largest drivers of this uncertainty, being the current status of federal and state support for local governments. Then I'm going to talk about disclosure. For issuers considering a primary offering, we'll talk about what that disclosure might include, and for issuers who are not currently thinking of getting into the market, what disclosures may be necessary or advisable in your situation. I should start by mentioning that this webinar is being recorded on Tuesday, December 8th, and will be airing on Thursday, December 10th. And this is relevant because Friday, December 11th is the deadline for a federal spending bill to avoid a government shutdown. Now, according to recent news reports, there's a potential that this bill will include some sort of COVID relief measure. And if Congress can't get there by the 11th, there's rumors of a week-long funding extension, giving them until Friday, December 18th to pass a bill. The baseline for these discussions has been a draft put forth by a bipartisan group of senators, including Mitt Romney and Joe Manchin, proposing $908 billion in COVID relief. And unlike past bills, Nancy Pelosi and Mitch McConnell are reportedly in discussions, making people think that this is more likely than prior attempts to occur. The key provision and sticking point is and has been funding for state and local governments. This bill, from its current reports, contains approximately $160 billion in funding for states. In the past, Democrats have been asking for closer to $1 trillion, with Republicans denying any funding for states or local governments at all, calling it an unnecessary bailout. Right now, I'm not aware of any details around how this $160 billion would be specifically allocated, or what the requirements might be to be able to access the money, other than broad statements by senators that it would be directly tied to COVID relief. So we'll have to see what happens if there's funding approved in the next few weeks, how much there will be, if there is anything for state and locals, and what the details are around that funding. Turning to the state budget process, in July, the state of California's budget was prepared for a substantial drop in revenues due to lower tax receipts than previous years and more demand for government services due to the pandemic, including cuts that would be triggered if substantial federal support wasn't received by October, which of course did not happen. So many issuers began their fiscal years worried about how they would weather this storm and what sort of temporary borrowing options would be available. Many were looking at interfund borrowing, tax and revenue anticipation notes, or other short-term borrowing options. Fast forward to a few weeks ago, the Legislative Analyst's Office reports that revenues have actually been much higher than expected in July, and the state will have a windfall, but only for this year. They expect there's going to be deficits beginning in fiscal year 21-22, which will remain through 24-25. So agencies may be granted a temporary reprieve, even though it's not clear at this time how exactly the windfall will be used. For example, California school districts and community college districts had expected payments to be deferred, which the LAO has now said may not be necessary. Best chance of clarity here might come from the governor's budget for 22-23, scheduled to be released in the middle of January. If issuers are still considering temporary borrowing options, we're happy to assist and discuss your situation. Please note, however, that if you're considering interfund borrowing, be very careful if you're considering bond funds. There are substantial pitfalls there, and in many cases it's unauthorized and can jeopardize the tax-exempt status of your bonds. Moving on to disclosure, if you are considering borrowing now, let's discuss what questions will be asked of you and what potential COVID disclosure might look like, because it is a safe bet that there will be something here. Virtually every disclosure document that goes out to the public market contains disclosure on COVID, and you should expect that lenders or underwriters will ask about it. The extent of the questions in the disclosure, however, will depend on the sector in which you operate. For example, the effects of the COVID-19 pandemic have obviously been much harsher on the healthcare or transportation sectors than for, say, utilities. Nonetheless, you should be prepared to discuss the effect of the pandemic on your finances and operations thus far and your response to it. Specifically, consider changes to expenses or revenues, the major drivers of those changes, and how results compare to prior years, in particular if you have adopted a revised budget. Investors might want to know about your current sources of liquidity, as well as any plans for additional liquidity. If you've applied for federal or state support and received that support, you may need to disclose how much it was and how it was used. If the stay-at-home orders, employee sickness, or labor issues have materially affected operations, consider discussing those as well. It's important to note here the concerns around forward-looking statements. Frequently, there's been a concern that These sorts of statements have to be properly qualified and accurately describe the assumptions used, with the concern that if the results don't match up, you certainly don't want there to be any idea that there's any liability. And here, SEC Chair Jay Staten has released a statement to the municipal markets in May that encourages disclosure, specifically requesting that issuers provide investors with as much information as possible about their current financial and operating conditions, and to provide investors with forward-looking information regarding potential future impact of COVID-19 on their financial and operating conditions. Importantly, SEC Chair Clayton has stated that the SEC, quote, would not expect good faith attempts to provide appropriately framed current and or forward-looking information to be second-guessed, end quote. So essentially, forward-looking statements still need to be framed appropriately, but if you're making a good faith effort, the SEC is not going to second-guess the disclosure. But what about issuers who are not in the market right now? If COVID is affecting your finances and your operations, do you have an obligation to disclose anything to your investors? And here, we note that if you have public debt outstanding, it's likely that you've entered into a continuing disclosure undertaking governed by Rule 15c212. This is the agreement or certificate that governs your annual filings on EMA and lists the events which, if occur, require an event notice be posted. I'm not going to go through the full list of 16 events, but I will touch on a couple where if one of these has occurred either due to COVID-19 or otherwise, you might be required to make a disclosure. Delinquency in a payment of principal or interest on your debt, a non-payment default if material, a ratings change, an unscheduled draw on reserves or credit enhancement due to financial difficulties, incurrence of a material financial obligation. And generally speaking, by financial obligation, they're talking about debt issues that are not otherwise public or guarantees or swaps related to those debt issues. So if you have incurred one of those, or if you have one of those already, and there's a default or an amendment to the documents or a few other things that reflect financial difficulties, that could be a listed event. Finally, bankruptcy, of course, or any sort of similar reorganization, if it were to come to that. However, even if these not occurred, we think most issuers should still consider voluntary disclosure. As I mentioned earlier, the SEC is strongly encouraging this and has stated that they will not second-guess good faith attempts at providing forward-looking statements that are appropriately framed. However, it's notable that while uncommon, there is potential for securities liability to attach to statements which reach the market, even if they aren't aimed at investors. For example, if statements by a mayor, high-level city official, board or city council member are made to the press or in public, and those statements are materially misleading or omit necessary information, there's a chance that the issuer can be held liable. Having a voluntary statement up on EMA, which is clearly aimed at the investor community, is a way to control what information investors should reasonably be looking at, so they don't go digging around on Google or in board meeting minutes and see statements that really are not intended for the investor community. Another potential approach is to consider adjusting the timing of your postings. For example, many continuing disclosure agreements require annual filings in February or March. However, if your budget is adopted in July, consider posting it before the deadline. And with that, if you have any questions about any of the items discussed, please reach out and we can assist. And I will turn it over to my colleague, Travis Gibbs.
I'm going to start with an update on public finance tax law related developments that have come out of Washington as a result of the pandemic. First, in May of this year, relief was provided by the Treasury regarding certain aspects of the public approval or Tephra requirements, so-called Tephra requirements. I will assume everyone is not familiar with Tephra. Certain tax-exempt bond transactions are subject to a public notice, hearing, and approval process that must be undertaken before the bonds are issued. And this is commonly known as a Tephra hearing and approval. Tephra is an acronym for the Tax Equity and Fiscal Responsibility Act of 1982, the legislation in which the public approval process was first enacted. The Tephra approval requirements are applicable to most bonds which are issued to support projects where the primary beneficiary of the bonds are not governments, such as bonds issued for 501c3 organizations, for airport and maritime port facilities, and for developer-owned family housing. For bonds subject to Tephra, current regulations require the bonds to be approved by the local government prior to issuance, and the approval must be preceded by a public hearing for which at least 7 days advance notice is given. So prior to the pandemic, the hearing was required to be held in person at a set time and place as set forth in the notice. But back in May, due to the pandemic, the Treasury approved temporary relief that permits telephonic hearings as opposed to in person through the end of the calendar year. Under this guidance, the hearing requirements can be satisfied by providing the public with a toll-free number or by internet-based technology connection, such as a WebEx or Zoom connection. The bad news is that the pandemic continues, of course, and in-person gatherings are still a bit into the future. But the good news, there is good news, and the Internal Revenue Service has announced that last month that the relief regarding Tephra hearings was extended through September of 2021. Second, also back in May, Treasury temporarily extended the time period that a state or local government can purchase and hold its own bond without being considered as retired or without the bond being considered as retired or extinguished. This relief can be helpful to issuers of bonds where the interest rates reset from time to time, including commercial paper. And that's because typically bonds with interest rates that reset permit or require the bondholder to put the bond back to the issuer when the rates change, and the bonds are then remarketed and sold to new buyers, but they're considered the same bond for tax purposes. For most issuers in normal market conditions, the bonds are received from existing holders and remarketed and sold to new holders more or less simultaneously. However, in times of market disruption, such as occurred in 2008 and following, an issuer may not have market access to accomplish the remarketing, or rates might have gone haywire, which may cause an issuer to prefer to not immediately remarket the bonds. If an issuer purchased and held its own bond such that the bond is considered as retired for tax purposes, any later remarketing of such bond would or might be treated as a new bond issue and not just a remarketing of the same bond. And if treated as a new bond, then such bond may not meet all the requirements applicable to a new bond and may not qualify for tax exemption. Pursuant to the relief provided in May, a governmental issuer may purchase and hold its own bond for all of calendar year 2020 without that bond being considered as retired. Accordingly, a bond purchased any time during the year and remarketed before year end would be considered a sale of the same bond. In addition, the general rule is and has been that an issuer can purchase its floating rate bonds and hold them for 90 days without causing a retirement or reissuance of the bond. And that 90 days is extended to 180 days pursuant to this relief, so long as the purchase occurs prior to year end, prior to the end of 2020. So therefore, except for purchases that occurred this calendar year for which a 180-day holding period is permitted, no further relief has yet been provided. Thus, absent new guidance, beginning next month, the permitted holding period will revert to 90 days. So third, temporary relief that allows electronic submission of certain communications with the Internal Revenue Service for things such as private letter rulings, that was announced in May. The general requirement is and has been that these communications must be through written materials with wet signatures. The relief permits submission by fax and email or by using an electronic signing platform such as DocuSign. The notice providing relief noted that paper submissions were still acceptable, but further noted that due to limited availability of IRS personnel caused by the pandemic, a delay could ensue if paper submissions are made. On this issue, there have been no further updates or extensions of relief. But I'll note this is an area where there's hope that the electronic filing relief can be made permanent. Fourth, the deadline for filing certain forms that were due on April 15th, including the 8038 form that must be filed for each bond issue, was extended to July 15, 2020. And this was the same relief that was given to individual taxpayers for their individual tax returns. There's been no further extensions of this nature, and I think the supposition is that working remotely has developed such that the systems are generally working and forms can be filed on a timely basis. Last, it's important to note that no relief was provided in the area where it is now most needed, and that is regarding more flexibility in issuing tax-exempt bonds to provide funds for operating or working capital needs. Most governments are experiencing significant negative impacts on its revenues. whether there are delays or reductions in sales or property taxes or other revenues or other types of impacts on their budget. And many are looking for ways to keep the lights on and the bills paid. The general tax law rules applicable to tax-exempt bonds require bond proceeds to be expended to provide capital items and not to pay operating or working capital expenditures, with some minor exceptions. Issuers have been looking for ways to address this problem, and I've been fielding a lot of questions regarding whether certain expenditures an issuer had been paying out of its general funds can qualify as capital expenditures, and if yes, then those costs can be financed with tax-exempt bonds. In regards to any further regulatory relief that may be coming in the future, about a month ago, the Internal Revenue Service noted that relief might possibly be provided if issuers ask with compelling facts and circumstances, and suggested that issuers should keep asking as the circumstances evolved. As noted, however, no relief has been forthcoming beyond that which I've described, and particularly regarding the limitations on financing working capital on a tax-exempt basis. So I'm going to now switch gears from the regulatory regime to legislation affecting tax-exempt bonds. Not much is happening on the legislative side, but there remains hope that the law may be amended to again permit advance refundings. And advance refunding is where new bonds are issued to refund or refinance existing bonds, usually due to lower interest rates and savings, but the existing bonds cannot be repaid within 90 days pursuant to its terms. And this occurs because it is common for tax-exempt bonds to be issued with call protection, generally for 10 years, and that means that they cannot be redeemed prior to their completion of the call protection period. Thus, when a bond is issued with 10-year call protection, and interest rates have fallen after the bond has been outstanding for 5 years, if refunding bonds are issued, the proceeds of the refunding bonds must be held in escrow until the original bond can be redeemed, which is 5 years in my example, 5 years later. If the escrow is for more than 90 days, the refunding bond would constitute an advance refunding and cannot be tax exempt. In that event, the refunding bond must be issued on a taxable basis. So prior to the Tax Cuts in Jobs Act of 2017, the tax law permitted one advance refunding in the life of a bond, but that one opportunity was eliminated in the Jobs Act. In the past year, there has been a significant uptick in municipal taxable issuance, and that's mostly due to advance refundings that no longer can be accomplished on a tax-exempt basis. So in July, a group of bipartisan senators introduced a bill to reinstate advance refundings, but that bill is stalled, and it's now unclear when and whether it'll return. Last, I'm going to make a brief comment about the Municipal Liquidity Fund, or the MLF. So what is the MLF? At the onset of the pandemic, market uncertainties caused big spikes in interest rates, particularly for municipal borrowers, which resulted in concerns regarding market access and liquidity for municipal issuers. The MLF was created by the federal government, wherein the federal government could serve as a lender of last resort to large governments if needed, and up to $500 billion was earmarked for that purpose. The program was designed such that the interest rate would reflect a premium above market rates, the design being that issuers that cannot access the regular markets could borrow through the MLF if needed, by issuing a short-term obligation such as a TRAN or a bond anticipation note such as a BAN. Terms were limited to 3 years, and eligible borrowers were only states in the largest cities and counties. It turned out that the market stabilized fairly quickly and interest rates remained low or returned to low rates and have remained low, and issuers generally had good market access. And as a result, only 2 issuers have used the MLF, and they are the state of Illinois and the New York MTA, both of which generally could not get better rates in the regular market at the time that they did it. The universe of eligible borrowers was expanded a bit, but there still have been only 2 borrowers. The current administration has decided to scrap the program based in part on the lack of subscription and the robust tax-exempt issuance volumes that exist and that continues. Both Illinois and the New York MTA has indicated they will request additional loans before it is scrapped, but no others have. Some commentators have suggested that just the existence of the program as a backstop has had a stabilizing effect on the market and are concerned about the impact of its absence, particularly if there are more circumstances where lockdowns or other events could cause market disruptions. Some also have suggested that a greater need for this program exists for small and medium cities and counties, and that an expansion of eligible borrowers would result in more subscription. We'll have to wait and see if the new administration and new Congress will renew the program. Graham and I hope this information was informative and helpful, and please reach out to us if you have questions or otherwise. Thanks and take care.